Welcome, dear learners. We were learning laws in relation to the poison. Under that, we discussed in the last class about the various penal codes applicable to the poisoning. Under that, we talked section 85, 86, 272, 273 up to 278, 284 of IPC, 324, 326 and 328 of the Indian Penal Code. Today we will learn what are the duties of the registered medical practitioner in case of poisoning. So the first is who are the registered medical practitioner? Legally, in the various legal provisions, a registered medical practitioner means any medical practitioner who possesses the required medical qualification which are defined under the section 2 of the Indian Medical Council Act of 1956. So this Indian Medical Council Act, that is the system of modern medicine, and whose name has been registered in the state medical register. So as per the penal provisions, doctors of modern medicine are only registered medical practitioner who to perform the legal duties. So the practitioner of other pathies are not given the authority to issue or to perform the medical legal duties. It may be that as the law is the state subject, so it may be that certain states may give the authority or the power to different pathies to perform the legal duties. That may be the subject to different amendments or the decisions from the different state legislatures. But in general, a registered medical practitioner of the modern medicine is only supposed to perform legal duties. So the doctors have two types of duty. One is the medical duty and another is the legal duty. So whenever medical duty is, you can understand about the treatment, diagnosis and the prevention and all the measures of related to the treatment of the patients. And the medical duty, although both are important for a doctor, but wherever there is a question that which duty to be given priority, then always you have to give the medical duty a priority than to perform the legal duties, especially in cases of emergency, where you have to first stabilize the patient, then you have to complete the legal formalities. Now, what is the legal responsibility in case of poisoning? So, a poisoning case will come as when either you are practicing in a private setup or in a government setup or in casualty or wherever, a person who has consumed the poison, that can be of any manner, either accidental ingestion, suicidal ingestion or with homicidal ingestion or any other episode, unknown episode could be there. The person in the comatose state or like that may appear before your specialty, before your clinic. Then in that cases, what all you need to do? So first of all, this all wherever there is the unnatural phenomena involved, so all these are the medico legal cases. So you have to first record the case as a MLC case in the first page of that case register, and then you have to inform the police. The information to the police is very important, that shall be given to all the MLC cases, medical legal cases. And it is not that certain books have written that some private practitioners are exempted, but it is not. Either the person is practicing in the government or in the private, he has to inform the police whether the case is of homicide, suicide or accident, because the certain books have written that the information has to be given only in cases of homicide. But this is the question, the reason being given by them is that section 39 of CRPC, which says that only in cases of homicide, 302 of the IPC, the public is supposed to give information to the police. But as a doctor is not a public person but a medical expert. So he is supposed to inform all the these conditions. So this is under the other sections which are applicable to the doctor. I will come in detail of each of these sections. So the doctor is supposed to give information to the police in any of the setup wherever he is. Another important thing is that you can think that how you will know that what is exact manner. The person will come with a particular manner. Suppose he is saying he has committed, it has happened because of accident. But unless the proper investigation will be done in the case, how it will be ensured that the case is of accident or suicide or the homicide. So the manner has to be ruled out by the investigating agencies. So it is well understood, it should be well understood that the information in all cases of foul play or unnatural phenomenon shall be given to the police officer without any doubt. So, and if a doctor fails to inform the matter to the police, then he may be held responsible under other certain sections of the Indian Penal Code, like under section 176 of IPC, he will be held responsible. So, when the patient comes, record all the findings and report the case as a medical legal case, and when you make the medical legal document, medical legal certificate, then it should be issued in 3 copies. One copy is given to the police, another copy should be given to the patient, and another third copy shall be kept in the hospital for the record purposes. So this shall be done by a hospital immediately. Then before going to the other rules, I will go to the what is section 39 of the CRPC says that public to give information in certain offences. So a general public is supposed to give, whenever they come to know about certain offences, then they have to give the information of such offences to the concerned authority. Every person aware of commission of intention any other person to commit any offence punishable under any of the following section shall give information to the appropriate authority. So these are all the sections. So here section 302, that is of murder, or that you can say of the culpable homicide, these all section shall be given to the information shall be given to the police. Rest other section are also important to know, being the even for a general public. So section 7, this one is your for the public to give information in certain episodes, point 8, 9, 10, 11, 12. So under these all IPCs, the public has to give the information to the police, and shall in the absence of any reasonable excuse, the burden of proving which excuse shall lie upon the person so aware, for henceforth give information to the nearest magistrate or police officer of such commission or intention. So such information shall be given to the nearest police or the magistrate of such commission, or even for the intention of the commission of all the list of the offences under the section 39 of CRPC. This is the excuse given by the doctors of certain doctors in certain books, that only in case of homicide the information shall be given, whereas doctors are not the public. First thing is this, they are the medical expert. So they have a separate duties. It is their legal duty that they have. And before that, this same under the Bharatiya Nagrik Sanhita, the same has been updated as under clause 33, and the various provisions of the clauses of the Bharatiya Nagrik Sanhita Nagrik CRPC is replaced as Bharatiya Nagrik Suraksha Sanhita 2023. So under that, this all list according to that Bharatiya Nagrik Suraksha Sanhita has been there. In the absence of any reasonable excuse, the burden rest all are the same, that you have to give information to the magistrate and the police officer. So rest all are the same, just the numbers of in this sections Bharatiya Nagrik Suraksha Sanhita has got changed. Further, the section 309 of the IPC that says that whoever attempts to commit a suicide is a punishable offence. So wherever offence is getting done, so you have to report to the police. So under the 309, it was the offence earlier. But now Bharatiya Nyaya Sanhita 2026 has deleted this offense. 309 is now deleted from the Bharatiya Nyaya Sanhita 2023. So this will no more be an offense to commit the homicide. Although it has been removed from attempt to commit suicide in the coming Bharatiya Nyaya Sanhita, but still abatement of suicide is there in the earlier also, and in the coming Bharatiya Nyaya Sanhita it will continue. So you cannot, how you will decide that this is a suicide due to abatement or not abatement. So you cannot judge on your own. So later may any allegation of the abatement of suicide might come. So you have to consider it as all as a medico legal cases, and self information shall be given to the police in such cases. Further, abatement of suicide. So if any person commits suicide, whoever abates the commission of suicide shall be punished with imprisonment for a term which may extend to 10 years or shall be liable to fine. So abatement of suicide, someone provokes some person to commit suicide, or someone causes the person to be in such situation that he is he had no more option except to commit the suicide. In those cases, this provision, abatement of suicide, is applicable. This section under the Bharatiya Nyaya Sanhita has been put same in the clause 108 of the this Bharatiya Nyaya Sanhita. So this abatement of suicide is continuing, but your attempt to commit suicide has been removed in the coming Bharatiya Nyaya Sanhita. So this doesn't mean that suicide in cases shall not be given, will be given, not information needed to be given, but still it will be required to be given. Further, negligent conduct with respect to the poisonous substances. So again, this is the example of accidental cases where if some accidents is happening, then it is duty of the doctor to give information to the police, so that the police will inquire whether this clause can be applicable or not. There is negligent handling of the poisonous substance or is there or not. So even in the cases of accident, we have to give information. So already in the last class we discussed negligent conduct with respect to the poisonous substances, and in that the punishment was 6 months with fine. We discussed the case of the housemaid who is leaving the bottle of the acid on the table, and the child consumes that bottle, and that causes injury on his body. So she will be held responsible under this section, which the punishment may extend with a fine up to 1000 rupees. The changes that has been brought under the Bharatiya Nyaya Sanhita, that it has been included in clause 286, with a change of fine just increased to, instead of 1000, the fine has been increased to 5000 rupees. Further, as we discussed, omission to give information to the public servant by the person who is legally bound to give the information. So doctors are also bound under this section, that they are legally bound to give information to the police of the commission of the offense. So if they omits to give the information to the police, then they may be penalized under this section as well. So whoever being legally bound to give any notice or to furnish information on any object to any public servant, as such intentionally omits to give such notice or to furnish such information in the manner and the time of required by the law, shall be punished with simple imprisonment, which may extend to 1 month, or with fine, or that may extend to up to the 500 rupees of the fine. Further, if the notice or the information required to be given respect the commission of an offense, or is required for the purpose of preventing the commission of the offense. One is you came to know this offense has been committed, and one thing is you come to know before commission of the offense, so that it can be prevented. So that also information has to be given by the person who is legally bound to give it, with a simple imprisonment. If he fails to give, then the punishment is of 6 months with fine that may extend to the 1000 rupees. Under the Bharatiya Nyaya Sanhita, the same provisions are under clause 211, with a change of fine increased to 5000 rupees instead of 500 rupees, and 10,000 rupees instead of 1000 rupees. This is the change. Just the amount of fine has been increased under the Bharatiya Nyaya Sanhita. So we as a doctor are also bound under this section that we have to give information to the police, that is public servant. Now the section 176 and 177 is also applicable to us, because if one has to give the information, and that also the correct information. If we give the false information, then also it is a punishable offense under the section 177 of the IPC, which says that furnishing false information, whoever being a legally bound, here legally bound to furnish information on any subject, any public servant, as such furnishes as true information on the subject which is known or has reason to believe to be false, shall be punished with imprisonment which may extend to 6 months or with 1000 rupees of fine. If the information which he is legally bound to give in respect of commission of offence as required to purpose of preventing. So in both 177 and 176, there is one is the you have information that has been committed, offence has been committed, another is the information which can prevent the commission of offence. So in that case, here the punishment is 2 years with fine. Just under this new Bharatiya Nyaya Sanhita, the clause 212 defines this section, and the fine increased from 5,000 from the 1,000 rupees. So this is a just a change in the Bharatiya Nyaya Sanhita. Now, what is difference between this giving, though already the crime has been committed and you are not giving the false information, and the one you have to prevent the false information? I can take this with an example. Suppose a landholder knows that a commission of the murder within the limit of his estate, that he knows that a murder has been committed in his estate, and misinforms the magistrate of the district that the death has occurred by the accident in consequence of the bite of the snake. So he will be guilty under the section part 1 of this section. Whereas suppose a village watchman, knowing that a considerable body of strangers are passing through his village in order to commit a dacoity in the house of Jed, a wealthy merchant residing in neighboring place of the that village, and then he is bound to give this correct information. But rather than giving the correct information, he says that we will fully misinform the police officer that body of suspicious characters passed through the village with a view to commit dacoity in a certain distant place in the different direction. So he is misguiding, he is giving the false information to the police, so he will be punished under the part 2 of this section. So this is before the commission of the crime, he is duty bound to inform the police. So this is 177 of IPC. So this is 175 of CRPC. So 175 of CRPC gives the power to summon a person to the police personnel. As you must be knowing that 174 of CRPC is about the police inquest. So police officers has been given the authority to inquire into the cause of death and the other crimes. So that power, that police officers who is proceeding under the section 174 shall have power through this section 175 to summon any person, 2 or more person, for the purpose of the said investigation. And any person who appears to be acquainted with the facts of the case, every person so summoned shall be bound to attend and answer truly all the question other than the question, the answer to which would be have tendency to expose him to a criminal charge or to penalty or the forfeiture. So a police officer can summon any person. So that includes the doctors also. If he is investigating officer, so he, for the purpose of his inquiry, he may summon a doctor. So and doctor is supposed to go to there and answer truly all the question to the best of his knowledge. If he does not gives information, if the facts don't disclose or cognizable to which the section 170 applies, such person shall not be required by the police officer to attend the magistrate court. This is a provision where if your need is not that necessity, then he will not take you to the magistrate. Otherwise, he will have to produce all the witnesses before the magistrate who are relevant for the investigation. and this power to summon person has been changed, has been made the clause 195 under the Bharatiya Nagrik Suraksha Samhita. There is an error here. Bharatiya Nagrik Suraksha Samhita 2023. The same provisions are under the clause 195 with some changes. So, what are those changes under this Bharatiya Nagrik Suraksha Samhita? That is the Bharatiya Nagrik Suraksha Samhita. BNSS, Bharatiya Nagrik Suraksha Samhita, clause 195. That all the provisions are same, except that even some person has been exempted from attending the police personnel. That is, no male person under the age of 15 years or above the age of 60 years, or a woman or mentally or physically disabled person, or a person with acute illness shall be required to attend at any place other than the place where such person resides. So, it is provision that such persons shall be attending through so the police has to come to their place. If the child of less than 15 years or age of over 60 years, or the woman or a mentally or physically disabled person, or a person with acute illness of such person, unless such person is willing to attend and answer to the police station at any other place within the limits of such police station. So, it is under this is a good, I will suggest this is a good change under the Bharatiya Nagrik Suraksha Samhita. So, further, what other role? One was so you must be now understanding that one, you have to give information to the police. So, if you don't give information to the police, then there are the various legal provision that punishes you for the not giving information to the police, and the police can summon you to extract the information related to the police and all other sections. Now, you have to collect the evidences in those cases, that is, collect, preserve and seal the evidence related to the case of poisoning. That is the third task that if I will number it, then it is third task that you have to do. You have to preserve the evidence, such as the gastric lavage fluid, vomitus, feces and urine, or whatever other relevant clothes can be, for onward transmission to the forensic science laboratories for chemical analysis. And final opinion of the death postmortem or any other clinical cases shall be given only after the report of the chemical analysis. If doctor deliberately fails to do so, he is liable to be punished under section 201 of the IPC. So, here if you fail to collect the evidence, so you may be charged under section 201 of IPC, that is destruction of evidence, charges under the destruction of evidence. So, what the section 201 of the IPC says is that causing disappearance of evidence of the offense or giving false information to screen the offender, to safeguard the offender, you are giving you are causing the disappearance of evidence. So, whoever knowing or having the reason to believe that an offense has been committed causes any evidence of the commission of that offense to disappear with the intention of screening the offender from the legal punishment, or with that intention gives any information respecting the offense which he knows or believes to be false. If you are with the purpose to screen the offender, you are either you causing the disappearance of evidence or you are giving the false evidence. In those cases, if the offender is going to be in the category of punishment of capital offense, then your punishment will be 7 years and shall also be liable to be fined. If he is punishable with imprisonment for life or up to the 10 years, in that case your punishment will be 3 years and is liable to be fined. If he is punishable with less than 10 years, then the punishment may extend to 1/4 a part of longest term of his imprisonment provided for the offense, or with the fine, or both. These provisions under the Bharatiya Nyaya Samhita has been included under clause 238 without any change. So, this is section IPC 201 that will be applicable in case of inappropriate or destruction of evidences. Further, intentional omission to give information, that may also be applicable to the doctors, that intentionally omitting giving information of offense, person bound to inform. So we are bound to give the information to the police, and intentionally whoever knowing or having reason to believe that an offence has been committed intentionally omits to give any information respecting that offence which is legally bound to give shall be punished with imprisonment of a description 6 months or with fine. Under Bharatiya Nyaya Sanhita, this is under the clause 299 with a imprisonment of 6 months and fine of 5,000. So fine has got increased. Says section 203. 201 is giving false fabricated evidence, destruction of evidence. 202 is giving the intentional omission to give information of offence by a person bound to inform. Whereas the 203 is giving false information respecting an offence committed. So this is applicable to the not the person bound to give information, but any person who is giving false information with respect to offence committed. Whoever knowing or having reason to believe that an offence has been committed gives any information respecting that offence which he knows or believes to be false shall be punished with imprisonment which may be 2 years with fine or both. And this has been used under the Bharatiya Nyaya Sanhita and clause 239 without any change. So this is the provision as per the IPC 203. Further, now this is the giving information, willfully giving false information. So informations usually are given to the investigating authorities. But when you go before the court of law, in those cases you are going to give the evidence. So in that case, willfully give the false evidence shall be applicable. Giving false evidence will be punishable under 191 to 192 and 93. These are the sections which are involved with the giving false evidence. So 191 says that what is false evidence? Whoever being legally bound by an oath or by an express provision of law to state the truth, being bound by the law to make the declaration upon any subject, make any statement which is false and which he either knows or believes to be false or does not believe to be true, is said to give the false evidence. Now, evidence, we will be giving evidence under the oath before the court of the law. So, who is legally bound by an oath to express provision of law to state the truth, gives the false evidence, then he will be charged under IPC 191. This has been used in Bharatiya Nyaya Sanhita under clause 227 without any change. Further, section 192. What 192 says is fabricating the false evidence. Fabricating, here it means the creation of the false evidence. You must understand like that. Whoever causes any circumstance to exist or makes any false entry in any book or record or electronic record. Suppose some evidence you have to submit it and you are intentionally adding something or you are removing something with the intention to fabricate the evidence. So you are producing a fabricating the evidence to produce it as a false evidence. Makes any document or electronic record containing a false statement intending that such circumstance, false entry or false statement may appear in evidence in judicial proceedings or in proceedings taken by the law before the public servant as such before an arbitrator, and that such circumstances, false entry or a false statement so appearing in the evidence may cause any person who in such proceeding is to form an opinion upon the evidence to entertain erroneous opinion touching any material to result of such proceeding is said to fabricate false evidence. Because of that, he may give the erroneous opinion. So this will be said as to fabricate false evidence. So this has been applied under Bharatiya BNS under clause 228 without any change. So I will give an example to better make you understand. Suppose a person A puts a jewel into the box of the Z with the intention that they may be found in that box, and this circumstances may cause Z to be convicted of thefts. So A fabricated the false evidence. So this is false evidence. So he created the false evidence. He created the evidence that is false. Another example could be a person makes a false entry in his shop book for the purpose of using it as a corroborative evidence in the court of justice. So A fabricated false evidence. Further, suppose A person with the intention of causing Z to be convicted of criminal conspiracy writes letter in imitation of Z's handwriting. He writes a letter in his Z's handwriting, purporting to be addressed to the accomplice in such criminal conspiracy, and puts the letter in place which he knows that the officer of police are likely to search. So A fabricated the false evidence. So under these all these provisions, this all will be punishable under the 193 of the section. So either he is creating the false evidence, 191 of IPC, or giving false evidence, or he is fabricating false evidence. In both the cases, he shall be punished under section 193 of the IPC. So we must, as a doctor, know this section as well, because so that we must be very responsible and should not fabricate or give false evidence before the court of law. So 193 of the IPC says punishment for the false evidence. That is, whoever intentionally gives false evidence in any stage of judicial proceedings or fabricates false evidence for such person of being used in any stage of the judicial proceedings shall be punished with imprisonment of either descriptions, which may extend to the 7 years, or with liable to fine. And whoever intentionally fabricates false evidence in any other case, that is, one is the judicial proceedings, and in other case, then he shall be punished with imprisonment of a description which shall be 3 years or liable to a fine. Any other legal case, that also will be a legal case, some tribunals and all those places. Under the Bharatiya Nyaya Sanhita 2023, the same IPC has been put under clause 299 with just the increase in the amount of fine has been clearly mentioned. That is 10,000 rupees in case of the part 1 whoever in the judicial proceedings, and 5,000 in case of any other proceedings. So these changes has been brought under the Bharatiya Nyaya Sanhita. So further, what all we learned is you have to make the seat, MLC seat, and you have to give information to the police. Then you have to collect all the evidences. Then you have to divulge all the information to the police, whatever information you have. Withholding the information and providing wrong information makes the doctor liable to be punished under section 202 and 193 of the IPC that we already learned. Now, if the patient is on verge of dying, then it is duty of attending doctor to record the dying declaration. Dying declaration and dying deposition. You must know the difference between them. Dying declaration is that when it is being recorded, how to record dying declaration properly, that shall be in the knowledge of the doctor. So, ideal in brief, a dying declaration, you have to note down the statement of the person. First of all, you have to tell the compos mentis of the patient, whether he is in the judgment making ability to judgment or not. Then doctor himself can record the dying declaration. The dying declaration shall have the mentioned initials of the patient, then his doctor's report that he is of sound mind or mental state or not, then his initial findings, examination, then his statement shall be recorded, and then at the end of the document, signature of the patient will be there, or thumb impression, or if he is illiterate, then thumb impression, and the signature of the two witnesses shall be there apart from the doctor, signature of the doctor. So these all should be there on the dying declaration. And if you are knowing that you must, I think the best way will be that you note down the dying declaration and then inform to the magistrate if the person is on the verge of death, because it will save if suppose by the time magistrate will come, in that case if the person die in between, so we may lose a good evidence, good dying declaration, good information that he may have given in proper manner. So we must not waste time in calling the magistrate, we must record the dying declaration if the person is on the verge of death, and at the same time we must give information to the police and the magistrate, so that he may be available at the time of noting the dying declaration. And when this dying declaration is noted by the magistrate, then that becomes the dying deposition. It is like the dying deposition is a term where although that is not commonly followed in India, dying deposition is like the whole of judicial proceedings are performed at the bedside of the patient. So that magistrate will come, the lawyers of his side and the defense lawyer will come, and they will decide at the scene of the death only, at the bed, as his bed, near bed is only all the proceedings, and they may decide the verdict of the case as well. So this is called dying deposition. If magistrate is not available at that time, then doctors may record the dying declaration. Even when the magistrate is recording the statement of such patient, the doctor should examine the patient in the regard of his consciousness and whether there is clear faculty of thought and judgment or not. So even the magistrate, when the magistrate has to record the dying declaration, then also the certificate of the composed mentis shall be given by the doctor. So this is another duty, that you have to record the dying declaration and to give writing of the composed mentis of the patient. Now, if the person dies or he has been brought dead, someone brought under the poisoning and he is already dead, then they are called the brought dead cases. So all those cases of brought dead cases, or those cases who died of those cases of all the cases of poisoning who died during the treatment, death certificate shall not be issued in all these cases. So what shall be done? That you have to make already you made the MLC. Now you will send the body for the autopsy examination for the proper certification of cause of death. So you don't have to issue the death certificate in such cases, and but you have to send the body for autopsy examination, where the appropriate autopsy surgeon will give the cause of death after the viscera examination report. Right? So this is the duty of a doctor. Now, in case of the food poisoning, it is the additional duty that you have to, apart from collecting the contaminated food and send to the FSL for chemical analysis, as you preserve the samples, you have to give information report to the public health officials, because food poisoning is the certain conditions which has to be given information to the public health official for the record and the other measures. So information to the public health officials shall be given in case of food poisoning. That is also duty of the doctor in case of poisoning. I am going to discuss an important section with you, that is 304A of IPC, because many times what will happen, that person dies. So the allegation of the accidental or the race and negligent act with respect to the handling of the poison might be under allegation which is not amounting to culpable homicide. So under those cases, this section may be applicable on the accused. At the same time, anyway, we are going to treat the patient, so an allegation of negligence may arise on any of such cases as well. Of the poisoning cases you are treating, you have not properly treated. So in those cases, this section may be applied. So you must know what is section 304A of the IPC, which says causing death by the negligence. So it says whoever causes death of the person by doing any rash or negligent act not amounting to culpable homicide. This culpable homicide is defined under 304. So if it is not that much of serious that he may be punished under the culpable homicide, then he shall be punished for the imprisonment of either description for a term which may extend to 2 years or fine or both. So this is basically causing death by the rash and negligent act. Under the Bharatiya Nyaya Sanhita, these same provisions are included under clause 1 and 2 of the 106 of BNS with some changes. What are those changes? That the punishment has got increased to 5 years from the 2 years. And another important change is that whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to the police officers or magistrate soon after the incident shall be punished with imprisonment for either description of a term which may extend to 10 years and shall also be liable to fine. So, this is especially for the cases of the rash and negligent drivings, that is particularly of the vehicle. So, already what is there, rash and negligent act is already there, but this part 2 has specifically added for the rash and negligent driving of the vehicle. If the vehicle owner escapes without reporting it to the police officer, then he will be punished for the imprisonment of 10 years. Recently, you would have heard that this particular clause caused the unrest among the drivers and their owners. So this is said to be the reason for withholding this Bharatiya Nyaya Sanhita and the other amendments under this criminal procedure codes. This, however, it is also said that this section will no more be applicable to the doctors. But there is nothing is specifically mentioned under this section that this will not be applicable to on the doctors as well. So I suppose that this section shall be applicable on the doctors as of now, even after the changes. So finally, to summarize everything, the doctor has two duty. One is the medical duty and another is the legal duty in case of poisoning. So medical duty is to treat the patient. So if the patient is under the emergency, so first you have to treat the patient, you have to stabilize the patient, then you have to do your legal duties. It is not that one duty is important and another duty is lesser important. Both the duties are important and both has to be performed. It is the only in cases of emergency or in certain circumstances where the life of the patient is at risk, then you have to give the priority to your medical duty, right? Then the second is what are the legal duty in case of poisoning. One is to inform the police, right? So in all cases of poisoning, or whether accidental, suicidal or homicidal, you have to give information to the police. Second is that whether you are working in the government setup or in a private setup, you have to give information to the police. Second is to inform the senior doctors. As any medical legal case comes, it's better to inform the seniors. Third is the collection of evidence. Collect all the evidence properly, label it, seal it and hand over in a proper manner with the proper take the receipt of the person who is further maintain the chain of custody, whoever person is taking next handling, so his sign and the receiving should be there on your paper. So even if you are handling the collected samples to the police, so you have to take the signature take the receivings from the police personnel on the samples. Case file shall be mentioned as MLC case. That is the third important thing, and that MLC file shall be maintained properly. All the case detail, all the case history and all the details shall be maintained properly. And then you have to prepare the MLC that shall have the proper format and the properly recording of all the information shall be there on the MLCC. Then arrange for the dying declaration if the patient is near to the death, or check the status of compos mentis if the magistrate is available for the dying declaration. In case of death, you don't issue the death certificate, send the body for the post-mortem examination, right? Food poisoning cases, you have to give the information to the public health officials. And finally, you have to maintain the record as per the guidelines, medical record keeping, and the records shall be maintained a minimum period of 10 years or up to the case has been finally disposed of from the court of law. So you have to preserve all the evidences and you have to keep the records for a minimum period of 10 years. With this, thank you so much for today. We shall meet tomorrow with a new topic. Thank you.